Rule-mandated disclosures when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagout.com. Your advantage if you're being sued by debt collectors. Under some state rules and the federal rules of civil procedure, parties to a lawsuit are required to make certain disclosures to each other. And you understand that federal rules don't apply unless you're in a federal jurisdiction, that is, federal court. So these rules of disclosure, when you have them, require you to provide certain information about the case to each other. The idea behind the rules was to reduce the amount of haggling over some kinds of basic information. Whether it's achieved any beneficial purpose at all is open to question. But stay tuned for a possible use of them for you. What the rules require you to tell the other party or parties probably varies from jurisdiction to jurisdiction, but they most likely involve variations of identifying people who are related to the action or could be affected by it, plus the documents and witnesses you plan to use. Some require a detailed statement of your legal claims or defenses. They do vary. Before you either make or attempt to use the other party's disclosures, you must read the rule requiring disclosures very, very carefully. For example, if the rule requires you to disclose all the documents you intend to use at trial, this could certainly be different from all the documents relevant to any claim or defenses you intend to make. If the other party is required to disclose documents it intends to use, this should have almost no impact at all upon your discovery, because what party to a lawsuit is ever going to use documents that hurt it? That is, the documents you would want to use. They're not going to disclose those. Also, intend is a word that could change over time. You'll get documents a week before trial called the debt collector's supplemental disclosures, and by then it'll be too late to prepare for them. The same, of course, is true for witnesses. Witnesses who may have information can change, and you need to ask what information they are in a position to know. Witnesses they intend to use is even less useful. You can't trust the disclosures at all in this regard. But here's a possible use for disclosures in a debt law case. If the party suing you has disclosed something completely generic, nothing more than a computer file, for example, from a supposed original creditor, and has failed to provide information linking that debt to the debt collector, i.e. information proving that they own the debt, you could consider taking either or both of two fairly dramatic actions. You could consider filing a motion for summary judgment, or you could file a counterclaim under the FDCPA, or both. Whatever you do, though, read the rule very carefully before you proceed. If you choose to file a motion for summary judgment, you might argue that since the debt collector can't disclose its connection to the supposed debt, or can't prove the validity of the debt, or whatever the disclosures fail to relate, its case should be dismissed, because it must have that evidence to obtain a judgment against you, and you don't, or in the case of proof regarding the debt collector's right to sue, you can't have that proof. Therefore, the case lacks an essential element. Look at the disclosure rule carefully, consider what it requires them to disclose and whether they have, and then consider whether they could prove their case without it if they haven't. As regards proof of the debt in question, or its ownership, I don't see how they could. Surely there would be a document they would have to use and disclose. Or secondly, you might take a look at the ethics requirements for attorneys in your jurisdiction. Are they required to have some sort of independent knowledge of the validity of the suit? Can you argue that the disclosures show they didn't make any such investigation as required by the ethics, since they don't have any of the documents they would need to make that? If you can, then maybe you could also amend your answer to include a claim under the FDCPA, arguing that failing to do that investigation was a violation of the Act. The theory there is that if bringing the action violated legal ethics, it was an unfair debt collection practice. These are just some thoughts on what might possibly be creative uses for disclosures that are generally regarded as purely a technicality or a nuisance. You need to consider your own strategy really carefully. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.